ever hear a song and think, that song reminds me of? Could be the music, could be the lyrics, could just be the rhythm. But how similar is it? Is it similar enough to infringe a copyright? How similar is too similar? Artists face this issue all the time. But similarity in copyright law is not always straightforward. A case filed against Taylor Swift in 2017 illustrates the point. The plaintiffs, Sean Hall and Nathan Butler, are songwriters who co-authored Play As Gun Play, which was released by the girl group 3LW in 2001. The song was a hit at the time. It includes the lyrical phrase, "Playas they gonna play, and haters they gonna hate." The plaintiffs claim this combination of players playing and haters hating was an original, unique lyrical phrase, a linguistic combination that no other artist had used prior to their song. The plaintiff's song follows this linguistic sequence with "ballers they gonna ball, shot callers they gonna call." Thus, in the song, there is a sequence of 4 groups engaged in 4 activities: playing, hating, balling, and calling. According to the plaintiffs, this was a unique and copyrightable sequence. So what did Taylor Swift do? In her 2014 hit, "Shake It Off," she included the lyrical phrase, "'cause the player's gonna play, 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 and the hater's gonna hate, 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 hate," throughout the chorus. According to the plaintiffs, 20% of the song is copyrighted material. And just like Playas, Taylor Swift's song follows the players and haters with actors engaging in 2 other activities: heartbreakers breaking and fakers faking. The plaintiffs argue that Taylor Swift undoubtedly had access to Playas and knew or should have known she couldn't use the material copyrighted by plaintiffs without a license and a songwriting credit. According to the plaintiffs, the music video for "Shake It Off" at the time of the complaint was the 7th most viewed video of all time on YouTube, with over 2 billion views. So the plaintiffs demand damages and an injunction to stop the infringement of their copyright. The judge in the Central District of California initially dismissed the complaint, finding there was insufficient originality in the phrases to claim copyright. But the Ninth Circuit reversed and sent it back. Originality to justify a copyright is a fairly low bar. Following some discovery, Taylor Swift has now filed a motion for summary judgment, asking the court to end the case because, she says, the plaintiff's claim is merely that "Shake It Off" copies the unprotectable idea of including 4 phrases, unprotectable ones, in the public domain in a sequence. And remember, copyright doesn't protect an idea. Rather, it protects the tangible expression of the idea. Furthermore, she argues, the music accompanying the lyrics in the 2 songs is very different. How does the court resolve such a dispute? Well, it matters to some degree where that court is, but in California and other courts in the Ninth Circuit, which handles a lot of copyright cases, the court uses an extrinsic and an intrinsic test. The extrinsic test looks at the work objectively, subtracts the unprotectable portions, and compares what remains of the 2 works for similarities. The intrinsic test is more subjective. It compares the protectable aspects of the 2 works for similarities in total concept and feel. This is looking at the ordinary person's subjective impressions of the work. To make a case for copyright, the plaintiff must prove substantial similarity under both tests. Taylor Swift is saying that there's no need to go to trial because, based on undisputed facts, the plaintiffs can't even get past the extrinsic test, the objective one, because the "player's gonna play" and "hater's gonna hate" phrases are in the public domain and not protectable. Otherwise, the songs are not alike. So what happens next? Well, in short, litigator's gonna litigate. As of this recording, the plaintiffs haven't responded to Taylor Swift's arguments. A court ruling on this is many months away. But if in fact the experts for the plaintiffs have admitted that the phrases are in the public domain, there's not a whole lot left to the plaintiff's case. And Taylor Swift could once again shake it off.